deliberations will be done in harmony, utilizing all the skills that you have given us, in determining the best way forward as we seek to develop Jamaica land we love. In Jesus' name, amen.
Amen. Thank you very much, Minister Dunn. Welcome again to another meeting of our Joint Select Committee on the Insolvency Act 2014. We have a straightforward agenda this morning. The last time we met, members asked that they would like for us to go through the amendments that are being proposed by the ministry. And we have the expert here with us, Mrs. Viola Evans-Roberts, who will take us through that. But before that, Madam Clerk, Mademoiselle Clerk, would you tell us if we have any apologies? I know of one from Senator Webby, who is not in the country. But also, apart from apologies, we have online Member Philip Paulwell. We have online as well Mrs. Shireen Golden Campbell. I think we have Senator Fraser Binns, who is online, and Ms. Janice Allen, I think also is online. The rules of the Joint Select Committee is that those who are online operate as full members as if they are present. So we do have quorum, and because of that, we're ready to start, and I'm going to ask Madam Clerk, if you could let us go through the process of confirming the minutes of July 6th, 2023. I'm going to ask if there are any Yeah, I did mention MP Miller is online, but I did not mention that Member Williams is also online, I noticed. So the minutes are before us. Do we have any amendments, corrections? If none, I'm going to ask, thank you very much. Senator Gale and Minister Dunn has seconded. Do we have any matters arising from the minutes? No matters, then I'm going to go to the new business, and that's a review of the proposed amendments to the Insolvency Act 2014. I'm going to ask Mrs. Viola Evans-Roberts, who is the supervisor of insolvency. She's acting at the moment.
Thank you. Before you go to that, there would have been a list of submissions. Can we just agree and accept them for the record?
Yes. What happened, in fact, is the last time we asked that, the committee asked that we advertise in various media.
Right.
And we did so, 3x15 black and white in both the Glean and the Observer. The public notice was published on the Parliament's website. Notice was published on the Parliament's Facebook and Instagram pages on August 21, 2023. GIS posted and boosted the notice on their Facebook, Instagram, and Twitter pages. The notice was sent to Jeremy Lee Nelson at the Ministry of Industry, Investment and Commerce for posting on the Ministry's social media pages as well as those of the Company's Office of Jamaica. However, the notice was not posted on their social media pages, I understand. Coming out of that, we had direct correspondence. In other words, we wrote the following. PricewaterhouseCoopers, Jamaica Chamber of Commerce, Jamaica Bar Association, Financial Services Commission, Private Sector Organization of Jamaica, Jamaica Bankers Association, Companies Office of Jamaica, Jamaica Manufacturers and Exporters Association, KPMG, and Institute of Chartered Accountants. My recollection is that Companies Office of Jamaica have already attended to this Joint Select Committee. We had, out of those, direct communication with various entities and the broader publicity. We had the following submissions, which were received from PricewaterhouseCoopers, Jamaica Chambers of Commerce, and Jamaica Bar Association. While we're not...
I'm not seeing Chamber of Commerce. We have PwC, Jambar, who has indicated that they have not fully completed, but they have sent a submission, Chair.
Well, we will make sure Jamaica Chamber of Commerce comes to you, but I hope before we leave. But I want to update you as well that the submissions that were sent to us were, in some instances, well, in all instances, did not refer to this. They had suggestions as that they want changes to be made, but they did not identify in which section of the existing law that they would want to have the amendment. So we've written back to them to say, give us some more particulars and some other clarification that we may have wanted. So those are yet to come back to us.
Okay.
So we're in the process of getting those submissions done in a more complete manner so we can have them fully presented to the committee for review.
As it's customary, Chair, we would also use the opportunity to invite them to present.
And that will be done.
Okay.
Once this process of, clarification back and forth is finished, they'll be invited to come.
All right. Thank you, Chair.
Okay. And so now we go to the Acting Supervisor of Insolvency, Mrs. Fiola Evans-Roberts. Mrs. Roberts.
Thank you, Minister. Good morning, everyone. These are the proposed amendments to the Insolvency Act. Amendment of Section 2 of the Principal Act, that's the definition section. This amendment seeks to replace the current definition of receiving order, which is currently defined as an order for court made under Part 5 of this Act, which provides for or authorizes the appointment of a receiver, with the definition, an order for court made under Part 5 of this Act that provides for or authorizes the appointment of a trustee of the bankrupt's property. This amendment is necessary to correct the reference to receiver where the applicable term is trustee. The amendments also seek to include the following new definitions: electronic, which has the meaning assigned to it by Section 2 of the Electronic Transactions Act, that is, relating to technology having electrical, digital, magnetic, wireless, optical, electromagnetic, or similar capabilities, and references to carrying out any act electronically shall be similarly construed. And working days, which has the meaning assigned by Section 2 of the Securities Interest in Personal Property Act. This act excludes Saturdays, Sundays, and public holidays from being considered a working day. Rationale for that is to provide the interpretation of these words where used throughout the Act. Amendment of Section 5 of the Principal Act is being amended. Section 5.1 provides for a stay of proceedings on a creditor to whom a proposal has been filed. The amendment seeks to remove the words to whom the proposal is made to allow the stay to apply to all creditors. This amendment is necessary as the wording of the current section is misleading and lends itself to be construed as saying that if the proposal is made only to secured creditors or a class of secured creditors, then the stay is not applicable to unsecured creditors. The proposed amendment is consistent with the Canadian counterpart. Amendment of Section 11 of the Act. This section identifies which persons can make a proposal under the Act. There was a proposed amendment to creditor, but after further consultation, we have decided to withdraw that amendment for the time being. Therefore, this section is amended at 11D to replace the word liquidator with trustee. The amendment replacing the word liquidator with trustee is to provide consistency in the reference to trustee. Amendment to Section 14 of the Act. This section provides for the convening of a meeting of creditors to be held within 21 days of the deemed assignment. A deemed assignment occurs where there is a failure by the insolvent person to file either a proposal or a cash flow. This section is being amended to remove the words 21 days in Section 14.4b and substitute the words 30 working days, therefore. This amendment will allow for sufficient time between the appointment of the trustee and the convening of the meeting of creditors. Additionally,
1 second, is that enough time?
Yes.
In your
Yes,
opinion,
Minister.
30
yes.
days should be good.
30 days should be good.
All right.
This section is also amended to include subsection 5A, which provides that the supervisor is to certify a newly appointed trustee where that trustee has been appointed at the meeting of creditors. For the trustee's appointment by creditors to be recognized, the supervisor is now empowered or would be empowered to issue a certificate of appointment. Amendment to Section 17 of the Act. This section provides for the commencement of proceedings for a proposal. The amendment seeks to redraft the current Section 17 and to include a requirement for the proposal to be filed with the supervisor and allows for the withdrawal of a security or surety tendered with the proposal if the court or creditors decides that it should be withdrawn. This amendment seeks to provide clarity and to allow the proposal to be filed with the supervisor in order to allow him to ensure compliance with the requisite timelines for proposals. Section 19 of the Act. This section...
Is it possible, I don't know, is it possible for us to write him, her, or just it's just acceptable to just leave it as him? I'm seeking now legal advice.
Usually him includes her, but if we wish to be modern...
Have we defined him to include her?
Yes.
And move on.
Amendment of Section 19 of the Act. This section provides for a trustee to call a meeting of creditors within 21 days of the filing of the proposal. This is in line with the section that we just read to remove 21 days to agree with 30 working days that has been recommended. Section 39 of the Act. Section 39 provides for deemed approval of the court after 15 days. The section is being amended to insert a provision which indicates that where there is no objection to a proposal, the supervisor shall certify that the proposal was approved by issuing a certificate in the prescribed form. This amendment will allow for the availability of a certificate of deemed approval in circumstances where there is a deemed approval by the court.
Okay.
Amendment to Section 47 of the Act. The marginal note of Section 47 is being amended by deleting the words "by the supervisor." This amendment removes the possibility of the perception that the supervisor can approve proposals. Amendment of Section 50. Section 50 provides for the effect of an annulment of a proposal. The section is being amended to rearrange the order of subsections 2 and 3. Hence, subsection 2 will become subsection 3, and subsection 3 will become subsection 2. Further, in subsection 2, where a proposal is annulled by the court, there is a deemed application for an assignment, and the supervisor is required to issue a certificate of assignment. Therefore, the reference to an order annulling a proposal has been made is being replaced with the words, a certificate of assignment has been issued. Also, the words, the order is made, is being replaced with such certificate is issued, which is consistent with the above change. Further, the period of 21 days is being substituted with 30 working days. The amendment corrects the error in reference to an order of the court being issued instead of the issuing of a certificate of assignment where there is an annulment of a proposal, and provides for the correct sequence in relation to the trustee's administrative actions, and also increases the time for the meeting of creditors to be held. Section 51 of the Act provides for a default in the performance of a proposal. It is being amended by deleting the words 21 days and substituting, therefore, the words 30 working days. The amendment allows for an increase in time for the convening of the meeting of creditors. Amendment of Section 83. This section provides for the approval or refusal of an application for an assignment by the supervisor. The section is being amended by deleting subsection 5 and rearranging same to make the provision clearer. A requirement is also incorporated for the trustee to notify the registrar of companies of the grant of an assignment. The amendment will provide greater clarity and require the trustee to notify the registrar of companies of grant of the assignment in the case of companies, since the Act was silent in this regard. Amendment of Section 85 of the Act. Section 85 provides for the property of the bankrupt to be vested in a trustee on a receiving order or assignment. The section is being amended by deleting subsection...
A receiving order of or assignment. You said or.
A receiving order or assignment.
Shouldn't be of.
It should be of.
Yes.
It should be or. The section is being amended by deleting subsection 3, which provides that the trustee is to file within 15 days a notice of his appointment under the Security Interests of Personal Property Act, and substituting, therefore, the following. Within 15 days of the making of a receiving order or the issuing of a certificate of assignment by the supervisor, the trustee shall file a notice of his appointment under Section 48 of the SIPO. And two subsections 4 and 5 are being redrafted to create paragraphs A and B for greater clarity. This amendment is being proposed since a failure on the part of the trustee to file his appointment may impact the estate negatively. Accordingly, it is important that the section be clear and not open to misinterpretation. Further, subsection 5 is now deleted as it is now captured in the amended subsection 4B. Amendment to Section 129 of the Act. Section 129 provides for an examination to be made of the bankrupt person by the trustee prior to the first meeting of creditors. This section is being amended by replacing subsection 1, which stipulates when the examination is to be done, who may be examined under oath, and what the person may be examined on, and substituting, therefore, a new subsection that has been redrafted for greater clarity. This amendment was necessary to incorporate the requisite punctuation for clarity. Amendment to Section 130 of the Act. Section 130 currently provides for an examination to be made of the bankrupt by the supervisor. This section is being amended by vesting this responsibility in the trustee instead of the supervisor, by replacing the word supervisor with trustee accordingly. Further, subsection 2 was redrafted to incorporate the requisite punctuation. This amendment was required to clarify the roles of the supervisor and the trustee. The trustee is the examiner as opposed to the supervisor. Amendment to Section 131 of the Act. The marginal note indicates that the trustee is to examine the bankrupt and others. This section is being amended in the marginal note by deleting the words bankrupt and others and by inserting persons connected to the bankrupt. This amendment is for the marginal note to be amended to reflect the provisions of the section. Amendment to Section 137 of the Principal Act. Section 137 provides for an automatic discharge procedure of a first-time individual being bankrupt. This section is being amended in the following subsections. Subsection 1, currently the 12 months is applicable to both paragraphs A and B and should only apply to paragraph A, which provides for an automatic discharge of the bankrupt. Further, paragraph B is being amended, restructuring the paragraph in order to make the last line, which reads, "There is no opposition to automatic discharge," applicable to both paragraphs A and B. And in subsection 4, the amendment now incorporates a time frame for which an application by the trustee for extension to file the trustee's report is to be made, which is 14 days prior to the expiration of the 11th month period allowed for the filing of the report. And by deleting paragraph B, which currently provides for the notice of the extension referred to in paragraph A to be sent to the first-time bankrupt, and substituting therefore the following, shall send the notice of the extension referred to in paragraph A to the first-time bankrupt and all creditors of the first-time bankrupt known to the trustee. The amendment to subsection 1 will allow for the purpose of the Act to be better served, while this provides trustees with additional time to complete administrative functions. It further retains the right of the bankrupt to apply for discharge before the expiration of the stated period. Further, in relation to subsection 4, a specific time frame within which the trustee may give appropriate notice to all concerned of the possible extension. The amendment also enables the creditors to be made aware that an application has been made to extend the time for automatic discharge. Amendment to Section 138 of the Act. Section 138 provides for an opposition to be made to an automatic discharge of first-time bankrupts. This section, which provides that the opposing person may promptly apply to the court for the hearing, is being amended by deleting the word may and substituting therefore the word shall to create consistency with the regulations. This amendment is necessary to require an application to be made promptly and to create harmonization between the Act and the regulations. Amendment to Section 139 of the Act, which provides for an automatic discharge of a first-time individual being bankrupt. This section is being amended by replacing the words "the trustee shall issue" and substituting therefore the words "the supervisor shall issue" and the words "certificate to the supervisor" with the words "certificate to the trustee." This amendment is being made since, as regulator, the supervisor has the responsibility of issuing all certificates and to provide consistency with the regulations, which provide that it is the supervisor who is to issue the certificate. The issuance of certificates should be by the regulatory body, especially since the certificate has the effect of a court order. This may also prevent fraud that could arise by having the certificate being generated by numerous persons or numerous trustees. Amendment to Section 140 of the Act. Section 140 provides for the bankruptcy of an individual to operate as an application for discharge. This section currently provides that the bankrupt is to receive a notice of waiver of the application to discharge and is being amended by deleting the words "bankrupt received" and substituting therefore the words "trustee receives," as it is the bankrupt who waives his right to apply for the discharge and not the trustee. Also, it is the trustee who receives the notice of the waiver. This amendment is intended to correct the error in the use of the word bankrupt instead of trustee. Amendment to Section 142 of the Act. Section 142 provides that in the trustee's report in relation to the application of a bankrupt for discharge, recommendations should be made in relation to whether the bankrupt has complied with all requirements, the total amount paid to the estate by the bankrupt, and whether the bankrupt would have made a viable proposal. This section is being amended by deleting the words "before the expiration of the 12-month period after the date of the bankruptcy" and substituting, therefore, the words "within 10 days after the filing of the report." This amendment provides clarity on the time frame in which the bankrupt must respond to the trustee's report in the event he disagrees with the recommendation. Section 144 of the Act provides for the powers of the court in relation to a discharge. This section is being amended to allow the trustee to apply for the discharge of the bankrupt. This amendment is made in light of the difficulties experienced when the trustee is unable to make applications for discharge after the administration is complete. Amendment to Section 148 of the Act. Section 148 provides for the bankrupt to report to the trustee and the court. Section 148 of the Principal Act is being amended by inserting next, after subsection 3, new subsections 4 and 5, which will also require the trustee to file a notice of compliance with the supervisor and for a certificate to be given by the supervisor, and a new subsection 5 to provide that where the bankrupt has complied with the conditional discharge of the court, the supervisor is now empowered to grant an absolute discharge without the parties having to go back to the court. The amendment to this section provides that where the conditional discharge has been complied with, the trustee is required to file a notice of compliance with the supervisor, and thereafter, the supervisor may issue a certificate of absolute discharge. Amendment to Section 155 of the Act provides for the introduction of Part 10 of the Act, which deals with the administration of estates. This section is being amended by inserting an additional subsection that will provide for a declaration of dividends to be made in the prescribed form under the part. The trustee at intervals advises the creditors how much is available to be paid to the creditors. It is now being required that this information be placed in a prescribed form. Amendment to Section 156 of the Act. Section 156 of the Act provides that the trustee is to send a notice to the creditors of the first meeting. The section is being amended by deleting the words "the 21-day period following" and substituting, therefore, the words 30 working days after. It provides uniformity throughout the Act to allow for more time to be given for the meeting to be called. Amendment to Section 183 of the Act. Section 183 provides for the duties of the inspector. Section 183(1)(c) of the Principal Act, which provides that the inspectors are to approve the trustee's final statement of receipts and disbursements, dividend sheet, and disposition of unrealized property, is being amended by inserting next after the words "dividend sheet" the words "in the prescribed form." This amendment is recommended as trustees are required to file this form on the supervisor when applying for a discharge. Accordingly, it provides certainty as to the information required and uniformity in the documents and details required in granting a discharge to trustees. Amendment of Section 223 of the Act. Section 223 provides for the functions of the supervisor, and this amendment is proposed considering a recent judgment. After subsection 3 of Section 223, add subsections 4 and 5 as follows. The supervisor may issue to a trustee acting as receiver, persons who provide counseling pursuant to this Act, directives with respect to the administration of this Act, and without restricting the generality of the foregoing, The directives may require them, 1, to keep such records as the supervisor may require, to provide the supervisor with such information as the supervisor may require, issue such directives as may be necessary to give effect to any decision made by the supervisor pursuant to this Act, or to facilitate the carrying out of the purposes and provisions of this Act with the insolvency regulations. Issue directives governing the criteria to be applied by the supervisor in determining whether a trustee license is to be issued to a person and governing the qualifications and activities of trustees. Issue directives respecting the rules governing hearings for the purposes of Section 2391. Issue directives where necessary prescribing the form of any document that is by this Act to be prescribed and the information that is to be given therein. 5, every person to whom a directive is issued by the supervisor pursuant to subsection 4A or B shall comply with the directive in the manner and within the time specified therein. This amendment is recommended because of a recent decision of the Insolvency Court to the effect that in carrying out its functions under Section 223, the supervisor has no power to issue directives to anyone. The judge reasoned that since the Act gives the supervisor specific powers, as in Section 240, and in Canada, the superintendent was given this specific power, since no express power is given, the supervisor may not give directives. The above provisions are adapted from the Canadian legislation. Amendment to Section 226 of the Act. Section 226 provides for the maintenance of public records. Section 2261D of the Act is being amended to correct an incorrect reference to Section 74, which provides for the duties of the receiver, and substitute therefore with the word Section 732, which provides that notices are to be sent to the supervisor. This amendment corrects the error in referencing Section 74 instead of Section 73(2). Amendment to Section 227 of the Act. Section 227 provides for the appointment of the government trustee by the Governor General. Section 2274 of the Principal Act, which provides for the government trustee to be paid such fees as the minister may by order, subject to negative resolution prescribed, is being amended by inserting next after the word fees the words and commissions. This amendment empowers the government trustee to collect fees and commissions for services. Section 228 empowers the trustee to collect both commission and fees, while this section only refers to the collection of fees. As such, there needs to be consistency. Amendment to Section 334 of the Act. Section 234 provides for conduct of trustees and is amended by adding after subsection 2 the following as subsection 3. No trustee who is a receiver of the property of any debtor shall, without the approval of the supervisor, accept an appointment to act as bankruptcy trustee in relation to the estate of the said debtor. This amendment is recommended as in Canada, where this is permissible, there are statutory checks and balances to minimize the chances of conflicts of interest. No such checks and balances are provided in the Insolvency Act. In a recent case, the supervisor was of the view that the trustee, being receiver of the secured creditor, ought not to be appointed bankruptcy trustee, applied to the court, but the court rejected that view. The receiver was appointed bankruptcy trustee, but the conflict of interest became obvious and resulted in the bankruptcy trustee resigning within 2 months of the appointment without properly carrying out the bankruptcy trustee duties and functions, and instead concentrated on his duties and functions as receiver. Amendment to Section 238 of the Act. Section 238 provides for the rights of the supervisor where there has been questionable trustee conduct. Section 2382 of the Act, which provides for the duty of the government trustee to act where the trustee appointed is removed or their license has been suspended or cancelled, subject to the creditor's right to appoint another trustee under Section 175. This is being amended by deleting the word Section 175 and substituting, therefore, the word section 237, which deals with the appointment or substitution of trustees by creditors. This amendment corrects the incorrect reference to section 175, which actually deals with the appointment of inspectors. Thank you.
Thank you very much, Mrs. Evans-Roberts, for that comprehensive review. Now, I want you to put this in human terms for us. So I'm going to ask you some questions. Define clearly what's the difference between a trustee and a supervisor, and which reports to which, or who reports to who, since these are people, and then explain the difference that the trustee will now have in law from what existed before, so there can be some clarity there, because people have been asking about this, and you know the questions that we've been getting. Mrs. Roberts. Sure, go ahead.
All right, so I'm reading in context with the amendment to 130.
Number what? Number what? Number
That-
what?
no, I'm looking at the Principal Act,
Yes.
wherein on page, what's this? On the page where you referred,
Tell me the tell me the number.
Number 14.
page 6, on page 6,
Page 6 and number what?
where you referred number 14,
Okay, thank you.
the amendment to section 130. And I'm reading it in line with that flows from 129, which speaks to the role of the trustee. And then in 130, you are now substituting the functions of the trustee, the functions of the supervisor, and substituting that with the trustee. What I want to understand, if there's in the first instance, an overlapping of functions or roles, or whether or not, the layers of the functions, if one is superseding the other based on this new amendment.
Which goes back to what I asked. Define what the supervisor, who is the supervisor and the role, define the role of the trustee and who reports to whom, and where does one authority stops and the second begins.
Yeah, I'm just trying to get the clarity in terms of the distinctions of the roles.
That's what I'm asking as well.
The supervisor is the administrator of estates.
That's the boss. That's the boss person.
Yes. The supervisor.
That's the role in which you are acting today.
The supervisor is
Yes.
the supervisor supervises the trustees. The supervisor supervises the trustees and regulates the licensing of private trustee.
And it's effectively the head of the organization.
Correct.
If I might, it's the CEO of the organization. Thank you. Thank you.
The connection is in 129 subsection 2, where it says the trustee may carry out subsequent examinations.
Yes.
So it assumes in my mind that in the first instance, the trustee would have sought to be the first layer of carrying out examinations. And then now, you have in 130, by your new proposed amendment, that the trustee, the same trustee that would have been carrying out in subsection 2 of 129, subsequent examination, is going to be taking on the responsibilities now in 130. Is there any overlap there? Thank you. In accountability?
No, definitely not. I think what section 130 did was set out in a better way the administrative steps, the details that the trustee should conduct in an examination.
It was relatively unclear.
It
so
was.
you've given clarity.
Yes.
So is there any need to expand now the role of the trustee by definition?
No, there is absolutely none.
Okay.
The trustee is the administrator of the estates. So at no time does the supervisor take on an administrative role and examine the bankrupts.
Okay, got
So
you.
even if the bankrupt is going to be examined, the trustee might invite the supervisor to be present, but the examiner is always the for
lead.
the administrative, is
trustee.
always the trustee.
So at some point in time, there can be a dual custody in terms of functioning.
No.
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 No, no, no,
No.
no.
No. The
Because-
supervisor
but one
supervises the function. The supervisor makes sure the trustee is doing what they need to do,
got you.
but never descends into the work of the trustee.
Got you, clear.
Or vice versa. In other words, you're making the rules very clear. One is the boss, the supervisor runs the place. The trustee goes out and does what a trustee does. You go and look at the details of the books. You make the assessment for the assets. You do all those kind of things, but the supervisor doesn't. But the trustee has to be authorized to do that.
Yes, Minister.
In what you're doing, right?
Correct, Minister.
Any other questions, members? Members online? There have been some questions about whether the creditors should appoint a trustee and all those questions that you have heard, and there sometimes even criticism that the thing isn't working fast enough. Do you have any comments on that, counsel or acting supervisor, who is also counsel?
Was initially proposed based on a discussion with the World Bank. It was their proposal, not any of our local stakeholders. However, after discussing it at length, Bar Association had that discussion. We are in the process of doing a regional harmonization of the Insolvency Act, and those external consultants also weighed in that it was considered not beneficial to the business person to have a creditor being able to intervene at that stage. It would not have the desired result originally intended, which is for you, the bankrupt, to be able to submit your proposal to restructure and get some assistance to do so. Because we don't know what would be the motive of this creditor. So it allows for a gray area that would not wish to go down that road. So that has been withdrawn, that proposal. The creditor would not.
No, the World Bank had.
Oh, the World Bank had. Right. It was a recommendation from them, not from any stakeholder or creditor here. So we're not
But the
obliged to go down
stakeholders
the
and
road.
creditors here, if I hear you correctly, came together and included the World Bank, and there seems to have been a consensus to exclude that, and that's where we've arrived at.
That's where we are now. Yes, Minister.
Any other comments or questions?
When I see an insertion of working days in any legislation, it highlights. But I'm gathering that the use of the term working days now as an insertion is only for the use of time frame, for holding meetings, for providing extensions and the likes. So I just have to make that clarity in case anybody...
On the record.
On the
You're
record,
on the
in case
record.
anybody asks.
Calculation
Yes.
of time.
Right.
But I also noticed that the terminology was in reference to a particular act. The SIPA Act was only, but why? Yeah, right.
Say that it's also in this act. So it wasn't intended to have more than that on the face of it.
In light of the conversation now about the future of work, and how are we looking at work, going forward, should we be ascribing working days specific in its terminology, or do we need to look at what the future of work would be as we amend a legislation like this?
I'm going to recognize Senator Gale, who clearly will have a view on that, and then I'll make a comment afterwards.
That's why I asked the question in terms of the reference to working days, what it specifically means in the context of this legislation. So maybe for clarity, in the definition, if you're going to utilize it here, then you may need to amend the definition area just to bring clarity for the purpose of its use in the context of this legislation. Yeah.
We're doing it for calculation of the days.
Of the days,
Of the days
right.
only.
Just to be specific.
Noted.
Right.
The broader issue of the future of work, those changes will emanate from elsewhere, not from this. Okay. Any other comments or questions? Then all that's left for me to do is to say very many thanks to Mrs. Fayola Evans-Roberts for coming to be with us this morning, our own councillor. Mrs. Yvette Sutherland-Reed from the ministry, others who have attended from the legal profession, a whole bunch of bright young legal minds over there. Thank you all for coming. And my colleagues on the committee, thank you so much for coming, both online and in presence, and present in the chamber. Thank you all. Madam Clerk, thank you. I'm going to accept a motion for the adjournment of this meeting from Senator Gale, and will be seconded by Minister Dunn. Thank you very much, gentlemen. The next date for this meeting, is it scheduled already, Madam Clerk? November 30th is the next date for the SIPA meeting, same time at 10 o'clock. Sorry, insolvency. This is the Insolvency Act we're dealing with, and that's scheduled for November 30th, right? Yes. Thank you very much. That then, 10 o'clock. That then concludes our meeting, and thank you all again. You want to turn on your mic there? Is it working? There you go.
Excuse me, Chairman. I was just informed by Ms. Auld that another
Can't hear you, dear. Speak louder.
I was just informed by my colleague that another Joint Select Committee meeting of Parliament is due to be held on the same day and same time for tobacco, I believe. Tobacco is at 2?
Yeah, okay.
So this will be at 10 and tobacco will be at 2?
Generally, we would have made sure that there was no conflict.
Okay.
So ours is in the morning and tobacco is in the night. And people smoke generally most in the night. Thank you all. This thing won't turn off.
This are the trend for all the youths them. Watch the trend, big up the trend, T-R-E-N-D. Big up the trend for education, teachers and the students. A fully bright future, yes, that are the new trend. Better governance, partner with the parents. Follow the big trend, elevate the youth them. Improve the schools, track performance, access and attendance. From infant, primary to university students. Turn up the skills training, full steam we are giving. Follow the big trend, elevate the schools. Yeah. Watch the trend, pick up the trend. This are the trend for all the youths them. Watch the trend, pick up the trend. T-R-E-N-D. For more technology, Yes, and better planning, quality education, that's what should be trending. From principals to EOs, everybody winning. Follow the ministry. We're changing the system. Watch the trend, pick up the trend.
This is Trend, Transforming Education for National Development, a program designed by the Ministry of Education and Youth to transform Jamaica's education system for a brighter tomorrow.
Do your part to prevent mosquito breeding. Mosquitoes will breed in any container that holds water.
Tightly cover water storage containers such as drums, barrels, buckets, and tanks. If this cannot be done, pour cooking